Good afternoon. My name is Craig Cook. I'm coming to you from the law office of Craig O. Cook, and I want to talk to you about bankruptcy basics, Chapter 7 versus Chapter 13. There are other different chapters, but we primarily focus on Chapter 7 and Chapter 13. So, what is the difference between a Chapter 7 bankruptcy versus a Chapter 13 bankruptcy? It can be very intertwining and very complicated in regards to the interplay between Chapter 7 and Chapter 13, and let me explain to you why. Way back before the bankruptcy code was changed some 15, 20 years ago, didn't matter how much you made or how much you owed, you could file a Chapter 7 and simply walk in, you have to give everything up, and you file and get a discharge. And that's an oversimplification the way it was before it was changed. Now you have what's called the means test. So say for instance, you come in and you want to file a Chapter 7 because you got a bunch of credit card debt, you got a bunch of medical bills, a lot of unsecured debt, you've got behind on a car, you want to get that back, and you come in and you want to file a Chapter 7. A couple things can happen to you that can nip you in the bud in regards to that. And one of them is if you make too much money. So let's say for instance you got 2 kids, the wife or the spouse makes $50,000, the other spouse makes $50,000 or $60,000, you got 2 kids who live in Fort Smith area code or Fort Smith area, rural country, there is a chance that you could not meet the Chapter 7 means test, which means you'd have to go into a Chapter 13. There's another reason why you might not be able to stay in a Chapter 7. So let's say for instance that the couple or the single person is drawing minimum amounts of money. In other words, just on Social Security disability, or got a small pension, small retirement, don't make that much money. But they bought a house 30, 40 years ago and they got the house paid for. And recently, if you've noticed, if you go try to buy a house that used to be, I don't know, $75,000, $100,000, $125,000, now it's $250,000, $300,000, $325,000. So if you've got a person or a couple that has a house that's paid for, that's $300,000, you can't or shouldn't be able to file a Chapter 7 if you elect what's called the federal exemptions. Now there's ways to get around it if you do the state exemptions, but you would have a difficult time in filing a Chapter 7 with that much of a valuable home. I say that with this caveat. You could still file a Chapter 7, keep your home, if what you had that was what's called non-exempt property was not very valuable, and you can come up with a payment plan to the Chapter 7 trustee, you can still stay in that Chapter 7. But that's few and far between. So the impediments to staying in Chapter 7 is you make too much money, or your home's too much, worth too much, and you don't know anything on it. So now let's go to Chapter 13. Chapter 13 can also be a little perilous for you. So let's say for instance that you don't meet the means test. In some circumstances you got to pay all of your unsecured creditors off. And Chapter 13 basically is where you are making planned payments to the creditors. Contained within that is the attorney's fees, our costs and fees, and the Chapter 13 trustees percentage they get, and then you pay out pro rata the unsecured creditors. If you are behind on a secured creditor, you also have to make that regular monthly payment. You've also got to make an arrearage payment, and you've also got to put in there what's called an adequate protection payment, which gives adequate protection to the particular secured creditor. For instance, on a car, that's what it usually applies to, because they depreciate in value of what they get. So usually you have an adequate protection payment, you got to add to that also. Chapter 13 bankruptcy can be perilous in that you can make too much money, get in a 13, owe too much unsecured debt, and may not be able to make that payment. And if you can't, you'll have to explore some other opportunities or other ways to try to stay in the 13 or hold out long enough to where you meet the means test of the Chapter 7. But usually the folks that come into our office, the reason they're in financial difficulties is because they don't make enough, and you don't ever have that situation where you have to pay out your unsecured creditors in toto. If you don't qualify for a 7 because you owe too much or you got too much equity in your home, you can sometimes file a Chapter 13 and be able to still make those planned payments. You can still come into 13 and pay out some of your unsecured creditors and still keep your home. Usually there's a difference in valuation between what the Chapter 7 trustee does and what the Chapter 13 trustee does that allows us to do that. The last one is which chapter is correct for you. So that just depends on how much money you make and how much debt you have and how much your home's worth. That's basically what's going to control that. If you don't make a lot and you don't have a home that's worth a lot, then a Chapter 7 is what you're going to be in. If you make too much, you're probably going to be in a 13 because you're not going to pass the means test. If you don't make much, but your home's worth too much, you're probably going to be in a 13 because you can't exempt all the equity in your home. If you have a bankruptcy need in the state of Arkansas, please contact us at the law office of Craig L. Cook by calling me, 479-783-8000, or contacting us through our website. There's several different ways, or send an email to me, craig@lawofficeofcraiglcook.com. Thank you very much.